Good morning, everybody. Thanks for being here. We're just going to give it a couple more seconds since we have a slightly delayed start, but we'll give just a couple more seconds for everyone to filter in. All right, the participant count seems to be slowing down, so I'll just jump into it. Welcome, everybody, to the 38th installation of the PANITS Training Academy. Today, we'll be discussing subsection 101, every patent attorney's favorite section of the code. Joining me is Chad Wieland, who will go over their introduction a little bit. But before we do that, I just wanted to share some Zoom tips. This session is being recorded and will be available on our website by the end of tomorrow. Please feel to ask us questions in the chat or through the Q&A throughout the presentation, and we'll be keeping an eye on those and we'll answer them as we go through. And for those seeking CLE credits in Delaware, Georgia, North Carolina, Pennsylvania, or Virginia, make sure to stay for the entire session and respond to the 2 pop-up polls and fill out this feedback survey at the end. With the housekeeping out of the way, my name is Sean Douglas. I'm an associate at PANITS Schwarzy. I am in the electrical engineering group, but my background is mostly in computer technology, software, AI, etc. And then I'll turn it over to Chad to introduce himself and jump into the presentation.
Well, thank you, Sean. Good morning. Today, we're going to be tackling the Section 101 patent eligibility issues that we've seen for the last decade or so. And I have some pretty good news. In 2025 to 2026, we've seen some represent a potential turning point. For over a decade since the analysis of Mayo, we've been struggling with a vague 2-step framework. The Federal Circuit found patents ineligible in 5 of 6 precedential decisions in 2024. Software, AI, diagnostics, all hit hard. But things are changing. Director John Squires was confirmed in September. His background, he was the chief IP counsel at Goldman Sachs, focused on AI, blockchain, and fintech. On his first day, he signed patents in crypto and medical diagnostics, 2 areas that have historically faced 101 rejections. This was on purpose. It was a public signing just to send a message to the world. At the AIPLA meeting in October, Squires outlined 3 pillars. Statutory categories remain controlling.
Chad, just before you go on, can you advance the slide?
Oh, thank you. Forgot I was in control of that.
Yeah, you're the captain here.
All right. So now I've lost myself, but thanks, Sean. I appreciate that.
No problem.
His background, he was in fintech, blockchain, AI. On his first day, he signed a couple patents to symbolically represent that there was a change in the air. He mentioned 3 pillars. Statutory categories remain controlling. Technological improvements per NFISH are eligible. And the something more means changes to the system architecture. What his message basically says is eligibility, and this is a quote, eligibility follows architecture. Today, we'll cover the landmark how do you pronounce it, Sean? Desjardins decisions. I don't know why I couldn't remember that. Key USPTO guidance, Federal Circuit tension, and practical strategies. So let's get started. I have to. All right. So the case of reshaping AI patent eligibility is ex parte Desjardins. Was decided in September and designated as presidential. Reason it's unusual is that this was one of the first actions Squires did. Facts: DeepMind, Google applied for an ML training model, machine learning training model to prevent catastrophic forgetting. That's where the training model or the model has been used enough times that it actually starts to forget its training. What they've done basically was to set up a first computer that had the model, it set the parameters, and then a second computer would get that same model and it would adjust the parameters for a particular task. But it would preserve the first instance, therefore not allow it to degrade. The examiner rejected the claims under 103, got up to the board. The board, sua sponte, added a 101 section rejection, calling it an abstract algorithm. I have to say it's shockingly direct, criticizing the APJs. So he convened an appeals review panel and vacated the 101, not the 103. Unfortunately, that killed the application. In any event, the key holdings were the panel agreed that the claims recited a mathematical concept. Alice was met, but step 2A, prong 2, for those familiar with the process, the ARP found the claims were directed to an improvement to how the machine learning model itself operates, not just applying math to a generic computer. Here are the two quotes that really stand out. Categorically excluding AI inventions from patent protection in the United States jeopardizes America's leadership in this critical emerging technology. Second, 102, 103, and 112 are the traditional and appropriate tools to limit patent protection to its proper scope. The message is 101 is not the primary gatekeeper for AI claims. Okay. So I think I actually skipped ahead a little bit there. What we have is in August 2025, we have a memo from Deputy Commissioner Kim, I think it's Chris Kim, told examiners and tech centers 2100, 2600, and 3600 about implying the preponderance of evidence standard. It has to show a greater than 50% probability of ineligibility before rejecting. This alone isn't enough. Recites versus involves the claims that merely involve math without explicitly setting forth that algorithms remain eligible. I'm reading from the text. When I was an examiner, when we got a memo like this reminding us of the standard, that meant that we were getting it wrong. And to some degree, we see that in the examining court that they get the message, but some examiners say it just restated the standard. The second is in December 2025, there was a subject matter eligibility declaration guidance memo sent out where they are encouraging 132 declarations to get the testimony of someone that the steps can't be done in a human mind. Invention improves computer functionality. Objective evidence like test data support eligibility. The bottom line is they're recommending, the PTO is recommending filing SMEDS, SMEDS separately from other declarations. In December, the MPP was updated to include Desjardins in sections 2106.04D and 2106.05. If you're a prosecutor, you know those sections well. Okay, slide 4. The recentive analytics thing is the Federal Circuit's take on things, and it shows a divergence in how people are viewing this between the PTO and the Federal Circuit. The claims used machine learning to generate an optimized TV broadcast schedule, holding ineligible because the court framed it as first impression. The quote is, whether claims applying established ML methods to a new data environment are patent eligible. The answer was no. The court found that ML applied to scheduling was abstract. Training a model incident to the very nature of the machine learning was not an improvement. The claims, again, another quote, claims are not made patent eligible simply because they speed up human activity. The critical distinction is that applied generic ML to a new data is ineligible. Applying generic ML to new data is ineligible. In Desjardins, there's some symmetry because the ML model was operated differently. But when we talk about recentive, it was just, are you just asking a different prompt is basically the way I view it. Director Squires is pro-eligibility. The Federal Circuit remains skeptical. The patents granted under the USPTO favorable framework may face the inevitable challenge of being upheld in litigation. And the trick is to build records that survive both. Some more good news is the Section 101 reversal rates that per patently owe data is in 2024 and early 2025. The reversal rates went from 8% to 12%. In October, they're 18%. In November, a whopping 29%. Could be a statistical anomaly, but it's definitely a direction that's going well for us. Key decisions are the ex parte Mercer, where they required evidentiary support for well understood routine and conventional findings. So they're trying to enforce that aspect of the examiner's job. Ex parte or Carmody, AI business methods eligible under the Desjardins framework, which is where we work. Sean and I work a lot. Sua sponte 101 grounds are dramatically reduced, which is a blessing because when you get to the board and they do a sua sponte new grounds of rejection, you have to ask them to change your mind in a request for rehearing, and requests for rehearing historically have almost never been granted. Implications, the appeals are more likely to succeed than they were, but it doesn't mean that they are going to succeed. This is outside our area a little bit, but I just have some notes there for those who are interested in medical diagnostics. And I'm going to talk about PIRA in a second. So let's let you read that. So there is a lot of activity in the congressional front. The Patent Eligibility Restoration Act is sponsored by our friends, Senator Tillis and Coons. The key provisions eliminates the judicial exceptions. Oops, sorry. So this is a bipartisan bill, which is great. It eliminates the judicial exceptions from Alice Mayo. Basically says they don't exist, but it maintains the statutory categories that have been in place since 1793. Creates specific ineligibility categories. Unintegrated math formulas, pure math. Pure mental steps. Unmodified human genes. And substantially economic processes. So pure business methods. The carve-out is inventions cannot be practically be performed without a machine are eligible. Just re-emphasize that. If you involve a machine, it's going to be eligible. Language isn't quite that clear because it does talk about an exception to that. Protects AI software and computational inventions that inherently require computers, is our point. Stronger support than ever. Former Director Annucci and Kapos endorse it. AIPLA supports it. Aligns with the administration's AI priorities. So this may well go through. Not a guarantee, but we will be monitoring it closely Call your congressman. If passed, it will change everything.
Fingers crossed.
Fingers crossed. Well, that's been our strategy, hasn't it?
Yeah, all right. Now we're going to shift in to the practical part, kind of how we take everything that Chad just went over and how do we actually apply that to drafting the application and then prosecuting the application. Um, so what we have here is that I've broken it down to kind of four areas that your specification needs to establish in order to avoid 101 rejections. First, you want to state a technical problem. You want to articulate the specific technical problem in the art. For example, what Chad was saying in before was, I think it's Desjardins, is the catastrophic forgetting in continual learning systems. That is a specific technical problem, not just, users are having trouble with data processing or some very generic computer issue that users are experiencing is not going to be enough. Then you want to define a technical solution. You want to describe how your invention is actually solving that technical problem. And you want to focus on the mechanism, again, not just results. And then you want to do technical improvements. You want to explicitly state the improvements to the technology. What is it improving? Is it improving performance, efficiency, accuracy, resource usage, et cetera? Is it preventing specific technical problems? For instance, Shad and I deal a lot with blockchain still. And one of the biggest problems that we have with blockchain especially in cryptocurrency, is double spending, the double spending issue of cryptocurrency. So one of the technical improvements would be how to prevent double spending. You don't want to say that you're just going to be preventing double spending. You want to explain how you're going to prevent double spending, how the processes and the logical structures within the claims and the specification are preventing that problem. And I alluded to it just before, but the fourth section is logical structures and processes. You want to detail the specific logical implementation, not just what happens, but how it happens. Next slide.
Ah,
Yeah, you're still the captain on this part.
no, I just had to.
So exactly now, where should we incorporate those four particular parts into your drafting techniques when you're actually drafting the application? One is in the technical field in the background, right at the beginning of the application. You want to frame it in the technical field as a computer technology improvement. In the background, you want to identify the deficiencies in the prior art systems, but you want to avoid doing purely business abstract framing. Again, you want to get the technical language in there. You don't want to just say avoiding processing times. You want to explain how you're going to avoid those processing delay times or whatever it is that your invention is improving on. In the summary of the invention, this is critical. Now, what I'm about to say could go into the summary of invention, or it could be maybe the first paragraph in your detailed description, depending on how you like to draft. I know a lot of attorneys like to keep their summary of the invention just essentially their claims in prose form. But you want to lead with the technical improvements. For example, saying improves computer functionality by, provides a technical solution to, etc. And the same goes for this third category, the advantages benefits section. You can include this in the summary, or you want it to be the first paragraph in your detailed description. Either way, because you want to frame this issue and the technical problem right up front in the very beginning of the application. You want the examiner to go through the rest of the application with all of this in mind so that he can see what you're doing. So again, advantages benefits section, I like to put this at the beginning. Reduce storage memory requirements as an example, improve processing efficiency, enhance accuracy and performance, reduce system complexity, etc. This section and this paragraph becomes incredibly valuable when you're starting to respond to 101 sections, because you want to be able to point to it in your arguments and when you're interviewing with the examiner. Next slide. And the first poll is up, so if you can go ahead and answer that, especially if you are seeking CLE credit. Let me and move that out of my way. All right. The next set is a claim drafting strategy. So after you've included those advantages and the benefits and framed a technical problem and solutions in the specification, now we need to make sure that we get those into the claims. So the first thing you want to do is you want to include the implementation details, specific data structures, processing steps with technical detail, configuration architect details. Yes, this narrows your claims somewhat, but it makes them defensible. it's kind of a balancing act there. How much implementation detail do you need to put in? And when it comes to AI in particular, it's a lot more than you probably want to. And especially in software, more and more, the data structures are becoming more important. So you want to show the how and not just the what. So looking at the bad example, a bad phrasing would be optimizing performance. That is very generic and kind of a business method and explains absolutely nothing. That's just a result. A better way of doing that is adjusting parameter values based on important measures to protect prior task performance. That's explaining how you're optimizing performance rather than just stating the business goal, as in the bad example. And the distinction between these two is actually what differentiated the claims in Desjardins and recentive. In recentive, the Federal Circuit found the claims ineligible because they were essentially just applying generic machine learning to a new data set. The how was just using machine learning. That's generic. But in Desjardins, the how was a specific technical approach to preserving learned information during subsequent training. Next, you want to reflect the ordered combination. Show the where, when, and how of how the elements are interacting with each other and how they're achieving the improvement. And again, just avoid pure result language. Focus on the mechanism achieving the result. Next slide, please. Next slide is an example. So this is a concrete kind of blockchain example. In the abstract version of the claim, it states right there, a method comprising, you're just storing data and rules. You're looking at that data and activity that comes in, and you're identifying events and taking action based on those events. That is something that could easily be done in the human mind if you look at it, because all you're doing is looking at one thing, comparing it to a rule, and determining whether or not it fits that rule or not. That tells you nothing. There's no technology really involved in that. The more technical version and the more defensible version, as you can see, I won't read it all to you, but it's telling you exactly how it's accomplishing that monitoring, how it's accomplishing identifying the triggering events, and how it's taking actions based on those rules. The key improvements are there are specific data structures recited in the technical version, like the blockchain wallet, smart contracts. There's technical implementation. You can say where it's taking place in a computer, memory processor, smart contracts, etc. And it solves a technical problem, blockchain wallet authority transfer in this particular example. And if you go to the next slide, I have another machine learning example, but this example kind of tracks directly to, again, the Desjardins example as before. An abstract version would just be a method of training a model comprising training, determining the parameters, and then training again. Again, high-level functional language, training on a task. Every machine learning system does that. Determining importance, how is it doing that? So then we look at the more technical version, and those answers become more clear. Again, I won't read it all to you, but the improvements there are it's explaining a specific mathematical technique that it's using, posterior distribution. It's detailing the mechanism, important measures, penalty term, and there's a technical implementation solving the catastrophic forgetting. So again, it's explaining how it's actually solving the technical problem, and it's providing the technical recitations for doing so. Next slide, please. All right, so now we've drafted our hopefully 101 defensible application. Now we're going to get into the 101 rejections and how to respond to them to the examiner. In general, it's called a three-part strategy, but those three parts are, if you're familiar, anyone who prosecutes in this area, it's step 2 of the Alice-Mayo framework, step 2A, prong 1, step 2A, prong 2, and step 2B. And so I'm going to go into these into more detail in the following slides. But just to go over them quickly, part 1, step 2, prong 1, does the claim recite a judicial exception? Here we're going to focus on whether or not how the examiner's looked at your claims. Has he overgeneralized them? Has he abstracted all the way out from all of your details, just 1 or 2 word description of what you're doing? Examiners love to reduce an independent claim that is a page long into just 3 or 4 words. I can't tell you how many times we deal a lot with financial technology, Chad and I, in our practice, and it'll be a page-long solution on how to solve a very specific technical issue that exists within payment networks or blockchain networks or whatever. And the problem that the examiner will identify under prong one is, oh, you're just processing transactions. That's what he's abstracted away from everything in our independent claim, and that's what he's saying is the abstract idea that the claims are directed to. Drives me up the wall every single time. Part two, again, prong two is the practical application. If there is an abstract idea, is it a practical application of that abstract idea? I'll go over one of my other kind of things that happen to me a lot in a little detail, where the incorrect standard is actually applied by the examiner. And part three is step 2B, ordered combination analysis, non-generic arrangement, and specific technical solution. You can go to the next slide. So here is the prong one. So these is kind of providing you with kind of some wording that I use a little bit and kind of abstract it away so you can generalize it to whatever you're doing. But what I was talking about in the overgeneralization here, I usually start my response with the examiner has overgeneralized the claim and mischaracterized what is recited. This characterization, whatever the characterizations be, such as processing transactions, abstracts away from the core recited technical limitations. And then you want to recite the core technical limitations that the examiner has seemingly ignored when he's reduced that page of limitations down to those 2 or 3 words of the abstract idea that he's allegedly identified. After that, I go into the end. I kind of detailed the ENFISH standard, and the Desjardins standard as well gets wrapped up into this, because the Desjardins memo and the decision and the memo essentially reminds the examiners of the importance of ENFISH and how they should be following it. And under ENFISH, the directed to inquiry, there's more than simply ask whether the claims involve a patent ineligible concept. They require the examiner to examine the character of the claims as a whole. The big takeaway, again, from ENFISH itself, with software inventions can make non-abstract improvements to computer technology just as hardware improvements can. And Desjardins reemphasized that and said examiners and panels should not evaluate claims at such a high level of generality. So again, that supports that overgeneralization argument again. So you just want to specifically tell the examiner that they need to look at the character of the claim as a whole, and not simply overgeneralize and abstract out little parts of it. Next slide, please. Next, we get into the prong two arguments, the practical application arguments. So as I touched on beginning, the incorrect standard that I see applied by a lot of examiners is that they don't actually look at the identified additional elements in combination with the rest of the claim language. So in other words, what I see a lot is if you look at some of the claims that I put up before in the example, the blockchain application, what they'll identify as additional elements would be the processor, the memory, basically the computer component parts, and it'll say that these additional elements do not provide a practical application. They're generic. But the actual standard, if you look at the guidance and this case law, is they actually need to look at those additional elements in combination with the other elements of the claims, the other recitations. They can't look at those additional elements in a vacuum, because, of course, if you look at those types of additional elements in a vacuum, they're going to be abstract, generic computer component parts, because it's just a processor. But you need to look at it in terms of what is that processor doing in the context of this claim. Again, here I usually cite to the ENFISH, Desjardins, and USPTO memo, again, to make sure that the examiner is taking into account the appropriate analysis of the claim. And also I detail how the claims themselves are integrating any alleged abstract idea, if there is one, into a practical application. Again, be concrete and specific, and make it easy for the examiner to see what you're actually improving. You can go to the next slide, which kind of goes into how do you articulate those technical improvements in this argument. This kind of follows the Berkheimer memo, which came out, I don't know, quite a while ago. Essentially, you want to identify the problem, describe the solution, state the benefits, map to the claims, and distinguish from the abstract idea. So again, the Berkheimer memo, what the requirements were, and under 2105 or 6 now, I'm forgetting, is you want to make sure that the specification identifies a problem, states a solution, and then the second part of that inquiry under Berkheimer is, do the claims recite that problem and that specific technical solution? So again, this is a way to do that and make sure that you track to that memo and track the claims to the requirements under the MPEP and under the case law. Again, what I like to do specifically in this part, if I'm dealing with a machine learning or an AI type of claim, you can track it specifically to like the elements that the APR or the ARP Appeals Review Board found to be eligible in Desjardins. How, if you have similar claim language, track it, point out like this is equal to this. Same thing in NFISH, anything. If the examiners like to see your actual claim language compared or tracked to claim language that was previously indicated as being patent eligible, it makes their job easier, and they're more happy and more willing to allow your claims under Section 101 if they can see that. You can go to the next slide. So the next slide is, after that, you go into Step 2B. This is kind of when you present your BASCOM style arguments. So the key principle is an inventive concept can be found in the non-conventional and non-generic arrangement of known conventional pieces. So the argument structure there is acknowledge individual elements may be known. Don't pretend processors and memories are novel in your argument. That's never going to fly. Don't say, unless it is an actual new processor that you've invented. But if you're just doing a machine learning or an AI type of application on existing computer hardware, don't try and pretend that the processors are not existing. You can't do that. It's not going to work in your favor. But you want to identify the ordered combination or the ordered architecture that you're using with those computer components that are resulting in the practical application or the novel concept that you're trying to go for. So again, emphasize the specific arrangement interaction. Use where, when, and how language. The claims recite a particular network control flow where specific operations occur at specific times in response to specific conditions. Literally, I usually list out the where, when, and how in little bulleted points in my responses when it comes to this. I'll track it all to, and I'll put a colon, and I'll include the actual claim limitation verbatim next to it, and I'll say this is how it's done, and I'll explain it a little bit more, and this is where it's done, and I'll put the claim language, etc. So again, what I find to be most useful and most helpful is including the actual claim language in your actual arguments. Don't just provide arguments and refer to your claim limitations kind of in the abstract. The examiners need to see the actual claim language in your arguments. It makes it that much more clear and concrete for them. Demonstrate non-generic, non-routine arrangement. Again, kind of the language I use, this specific arrangement is neither generic nor routine. The use of posterior distribution approximations to compute importance measures is a specific technical approach not found in conventional machine learning training. That would be the phrasing I would use from, again, the Desjardins type claims where they were improving upon machine learning models. And then show the technical effects from the combination. This ordered combination produces technical effects beyond the capabilities of individual elements. List them. The BASCOM argument says we're using known computer components in a novel way that achieves a technical result that wasn't previously possible. You need to lay that out for them in explicit terms. You can go to the next slide. And these are the macro type style arguments. These kind of fit into Step 2A, prong 2, and 2B, depending on how you phrase your arguments and frame them. That's why it makes sense that this was actually before BASCOM and under Step prong 2A. But specific way versus idea of a solution. So the claims must describe a specific way to solve a problem, not merely the idea of a solution. Again, I think I used the example of, optimizing performance. That's the idea of a solution. That's the end result and pure result-based language. But how are you actually doing that is what you want to actually describe and point out to the examiner. Again, the distinction is between claiming a result versus claiming the method. You want to identify the known problem, present the claims, recite a specific way to solve the known issue of a technical problem. Um, and I'll add here what Chad and I have found, and in our firm in general, we are playing around with some of the AI tools that are out there. And one of the good things that the AI tools are very good at or can help you with is framing the technical problem that is being addressed. If in case you didn't draft your application and you didn't do what we did, what we suggested before in our drafting suggestions, you can input a prompt into the AI and ask it what is the technical problem being addressed by this application, and the AI tools are actually pretty good. I'm referring to like ChatGPT, Claude, and other IP specific ones are very good at providing you with some of the language that you might want to use in framing the technical issue. Again, if you have not drafted the application with those specific points in mind, that is one way that might help you in framing this idea and these arguments. So again, identify the known problem, detail the specific steps. The claims recite a series of specific steps for the solution, including, and here again, I do a bulleted list. What are the specific steps? So, you know, the data gathering, the how you're actually analyzing the data, what's analyzing the data, what are you doing different. Again, you just want to lay it all out for the examiner. And here I provide a kind of argument template and the kind of language that I like to include in my responses. Again, analogous to macro. Again, if you can track the claim language that you are actually using in your claims to the language that was used in the case law, the examiners love to see that, and it makes it so much easier for them. Next slide. So again, this is kind of just a general prosecution lens, some general tips to go over to implement what we just went over. Review the specification with the 101, with subsection 101 lens. Ask yourself, does the specification frame the invention as a technical solution? Are technical improvements explicitly stated? Is the how sufficiently detailed? Are logical structures and processes described? And I saw a question pop up in the chat. Are you not afraid to lay open info at ChatGPT to foreigners? May ChatGPT use your data and publish it? The answer to that is if you are using the publicly free version of it, yes, I would be afraid to do that, and I would not do that. We use the actual enterprise version of it, where it's explicitly stated in the contract that they will not use our data for training, et cetera. And obviously, just like any type of software, we have to take that contract at their word. And so we not use. So as long as you're using a paid version of most of these AI tools, and again, you should verify this, if there's not using the data that you're inputting to train their algorithms. Now, the other caveat to that is if you're just on the prosecution side of that lens, if you're just asking, does this specification, what is the technical problem being addressed by the specification? If the specification is published, all the data that you're inputting into that is already publicly available. There might not be so much privacy concerns or confidentiality concerns that you need to worry about in that sense. But if you are, again, the paid versions are your best bet if you are worried about privacy. Again, include advantages section, have a dedicated section listing the improvements that your claims are realizing, such as the ones listed here: reduce storage, improved processing, enhanced accuracy, reduce system complexity, the specific technical problem being addressed. And then balance the breadth with sufficient technical implementation details when you're actually drafting the claim. Include as many specifics in the independent claims as you're comfortable with without trying to overly narrow the claims for you. And obviously, you have dependent claims to add a much more structure. That way you can actually, at least you have recited all the structure you can in dependent claims. Maybe the examiner will be more willing to allow a dependent claim, then you can at least just roll up the structure into the independent claim. At least you're presenting those structures to the examiner, whether in your independent claim or dependent claims. You can go to the next slide. And poll 2 is now up for those seeking CLE credit. So responding comprehensively to 101, again, address all prongs of 101. If you just think that your claims should succeed in not because they don't recite an abstract idea under prong 1, don't stop your analysis there. Our suggestion, and what I find, it is much You are much more likely to succeed if you address all three prongs, prong one, prong two, and step 2B of the Alice Mayo framework in your actual response. Don't just say, well, we don't recite an abstract idea because of this, and therefore we don't need to get to prong two of step 2A. Again, don't concede the abstract too quickly. Again, the examiners love to abstract out a 3-word explanation, description, abstract idea of your claim. That is, again, might be a page long. Don't concede that. Again, argue that the examiner has overgeneralized and explain why they've overgeneralized the claim language. Use the current case law. The examiners don't just want to see arguments in kind of with no support to the actual case law, the USPTO memo, the guidelines, the PEG, et cetera. So cite specifically to those, and if you can, track the claim language that you have to the claim language involved in the case law and the memos, et cetera. Again, we found recently increasing success in tracking claims to the Desjardins and the USPTO memo that came out subsequently, directing the examiners to pay attention to the Desjardins decision. So that's just anecdotal evidence. We've seen in the last 2 months, the 101 rejections that we've responded to, we've gotten some allowances from responses that have included these types of arguments. So in our personal experience, this has been a successful strategy. The next general tip we have is always request the examiner interview. Because you want to it helps you gauge the insight into how the examiner is viewing 101. For me, ideal in technology centers that usually have a lot of experience in 101. So typically I'm not dealing with an examiner who has no idea what's going on, but I have ended up with applications in other art units where the examiners are not as experienced and versed in 101, and you can kind of gauge how well they are dealing with that in an examiner interview that you might not otherwise be able to kind of glean from the actual rejection itself. So in the examiner interview, you want to discuss everything. You want to discuss the technical merits of the invention. You want to tell them what the technical problem that you're addressing and the technical solution that the claims are realizing. Educate the examiner on those, find common ground on the claim amendments, et cetera. Consider the strategic amendments. Add technical details from the specifications to the claims if needed. If you want to suggest possible amendments during the examiner interview, these are the type of amendments that you might want to discuss with the examiner. Are there specific technical details within the specification that the examiner maybe has read that they think would help the claims get out of 101? There's a couple of examiners that I run into that are usually always willing to work with you and go through the specification with you and identify particular paragraphs that detail certain technical implementation details that they would like to see in the claims. You wouldn't know that if you didn't conduct the interview. So there are helpful examiners out there, just as there are unhelpful examiners out there, unfortunately. But if you luck out and get one of the helpful ones, the examiner interview is invaluable in that sense. And just while we're talking about examiner interviews, I will say there was guidance and they changed the internal rules at the USPTO last year, where examiners are only going to are required to grant you one interview in a round of arguments. So after your non-final rejection, they will get to you an interview, but they are increasingly not granting interviews after final office actions, especially if you are not going to suggest amendments to the claims in that interview. I've had several examiners now email me after I've requested the interview after a final office action, asking if I intended to amend the claims. And if I said no, I was not intending to amend the claims, or I was unsure if I was going to amend the claims at this point, because I wanted to discuss 101 with them, they're increasingly rejecting the interview requests and asking just for me to submit my arguments on paper. So anecdotally, that has been happening to me a lot, and I know it's been happening to other practitioners a lot as well. You can go to the next slide. So again, here are just boiling everything down, red flags to avoid. purely result-based claims, a method of improving computer performance. You must show how the performance is improved. Don't just claim the result. Generic computer language, using a computer to specify the particular computer implementation. What specific data structures, what specific processing steps are you using? Avoid overly broad abstract claims, a method of organizing data. Add technical implementation details. How is the data organized? What specific data structures is the data being organized into? And again, specification without technical detail. You want a business-focused description without technical architecture won't survive 101. You have to establish the technical foundation in the actual application itself. You want to have those fallback positions you want to set yourself up for success as much as you possibly can. And go to the next slide. And so these are some AI machine learning specific considerations that you can take into account for when you're actually drafting the application and claims and kind of formulating your arguments. Focus on system improvements, model training efficiency, reducing comp requirements, improved accuracy, et cetera. Address the known AI ML problems. Identify the problem that you're solving. Again, catastrophic forgetting, overfitting, underfitting, training instability, computational bottlenecks, data efficiency. And again, this doesn't have to be limited to AI and machine learning. This goes to any type of software application. What problems are you solving? Again, for what we do a lot in our financial applications, processing times are a huge problem that we run into. How are you reducing the processing times? How are you reducing computational overhead, et cetera? Environmental factors. If you're dealing with blockchains or AI data centers somehow in your claims, how are you improving environmental efficiency, computing efficiency, and saving that? Reducing all of that is another argument that you can put in for a technical solution or a technical problem that's being addressed. We've all seen the news stories of all the AI data centers that are going up and draining a town's entire water supply or their electricity grid, and all of a sudden you get towns with rolling blackouts. There are technical solutions that that your claim or your invention is doing to prevent that or to help address that issue. So that's just another example. Again, describe novel architectures, specific neural network structures that you're doing, training procedures, parameter adjustment mechanisms. Again, going kind of in the AI space, some of the claim elements that you want in there, if you are using existing machine learning algorithms, you want to detail the data inputs that you're using, detailing the feedback mechanisms that you're using. You want all of those kind of details. How are you manipulating the output, et cetera, in order to get over those one-on-one, especially if you're using off-the-shelf algorithms. If you're training your own algorithm, you want to make sure that you're claiming that training of the algorithm. You want to describe, and in the specification, you want to describe specifically how you're training that algorithm, supervised learning, unsupervised learning, et cetera, all those more technical details. You want to go into all of that detail, especially if you're going to be filing abroad. U.S. is one thing, but again, I would say Europe it's especially important that you include those types of details as well. Go to the next slide. So here again, kind of condensing down everything I talked to into kind of what my response template looks like. Again, not too shocking. I follow, that chart in the PEG, the eligibility guidelines from the USPTO that we're all probably familiar with Step 2A, Step 2B, and Step 2A is divided into Prong 1 and Prong 2. That is exactly how I walk through my response outline. So introduction, summary of why the claims are patent eligible, summary of maybe what the examiner is arguing. Then I jump into Prong 1 analysis. Again, examiner overgeneralized the claim, character as a whole is technical, cite Enfish and Desjardins. Then next I jump into the Prong 2 analysis. I say, again, I'm usually arguing that it is eligible under Prong 1, but I'm going to still complete an analysis under Prong 2 and Step 2B. I'm not going to just stop at Prong 1. I will say something kind of in the beginning of my Prong 2 analysis, like assuming in arguendo that the claims are found to recite an abstract idea, then applicant believes the claims recite a practical application of that alleged abstract idea. Something like that you want to include just so that you can continue the analysis. Again, ENFISH ex parte Desjardins, the USPTO memo, technical improvements, macro and BASCOM arguments, etc. Step 2B, non-generic arrangement, BASCOM, everything, and then conclusion, request withdrawal of the 101 rejection, etc. You can go to the next slide. Again, here, examiner kind of interview strategy as you go in. Just set the stage, before the interview, send an agenda. It's extremely helpful because you don't want to if you just go in without an agenda and you just start talking at the examiner, they may not have even they won't bother looking at your specification. They probably won't even bother looking at the claims ahead of time. They'll just join you with no kind of insight into where the conversation is going to go. You at least want to frame everything out for them so that you can have an actual back and forth conversation with the examiner. Otherwise, you're just going to be talking at the examiner, and the examiner is just going to go, I need more time to consider that or think about that. So agendas are important, and they're important for setting the stage and framing the conversation that you want to have. Again, focus on technical merits, be collaborative, understand the examiner's concerns, discuss potential claim amendments. Again, ask them outright. Some of them are very helpful if you ask them, are there things in the specification, the detailed description, that you think would be helpful in addressing the 101, or that you would think would push us closer to an allowance or moving the application forward? You'll be surprised that a lot of the examiners, I would say more than 50%, are usually very willing to help you and actually have a conversation about it rather than shut you down and say, well, that's your problem, not mine. Again, follow up. This is required under the rules, but you should be sending a summary of what you agreed upon in the interview as well. I usually include that in my response as well. Now you can go to the next slide. This is just a brief case study. I won't go through this. It's just a pre-Desjardins, post-Desjardins approach. Everything that I've said here is just analyzed. I won't go through it in detail as we are coming to the end. You can go to the next slide. These are just future outlook and trends. Again, these are all just kind of summaries of everything Chad and I have talked about throughout this presentation. I'm more interested, again, the next slide, well, everything, the key takeaways are all just summaries of everything we talked about. And since we only have 3 minutes left, I think, Chad and I, if there are any questions, I don't see any that are in the chat currently, but if anyone else has any questions they would like us to address now, we would be happy to do so in the next couple of minutes. Otherwise,
we had a few that we passed over. From Paul, he asked, seems to me that the USPTO is now comes closer to the EPO practice in this regard. And I think what you're talking about is the EPO's practice, actually in patentability reviews, of striking through anything that they view as business method and leaving a processor, a memory, and an interface. I agree that is the same result. It's kind of for the same or different reasons, but it is very difficult to deal with when they don't read the claim as a whole. That's why Sean was emphasizing really pushing the idea of reading the claim as a whole. And so many examiners don't get that right. And then going down a little bit further. I'm sorry, there's so many technical issues. Would the PURA bill apply retroactively? The answer is it's like any other law. When it goes into place, it'll be the law of the land. So if you have a litigation and it goes into effect, presumably, actually, I'm not a litigator, I shouldn't say this, presumably that you would have to apply the law that occurred at that time. But I'm not really sure what you mean by retroactively. If you lost your patent to litigation or abandoned an application, you wouldn't be able to go back and revive it. Sean, do you have any thought on that? I mean,
yeah, I don't think I've seen a law like that go retroactively, because the amount of work that would create for the patent system in the USPTO to go back and reanalyze an open prosecution, all that, it's not going to happen. So I think the safe bet would to say no, it won't be retroactive. think I didn't see any more questions as I was going through, and we're kind of at the end of our time.
We got one
So,
more minute. There's one more question.
oh,
The Google DeepMind thing, the reason that the 103 rejection was fairly strong, but interestingly, at the ex parte level, two of the judges, APJs, said it was unpatentable, and the third one actually dissented, which is really rare. But that was it. They gave up because of the obviousness rejection, presumably.
yeah. And we just got another one. Could AI drafting software be prompted to incorporate the ex parte Desjardins argument? Yes, yes, it can. In short, in your in prompts that I use, one of the parameters that you should be putting into your prompts is kind of constraints where the AI algorithm should be looking for its answers. And one of those is you can attach the Desjardins decision to the prompt and say, include arguments that track to this memo, for instance. So absolutely, you can prompt the AI algorithm to include the Desjardins decision.
One thing about that is when you want AI to stay within a set of documents, whatever they are, there are certain prompts that you should be using to tell it not to go out and find answers to fill in the gaps to your questions and to admit that it's making a mistake or it doesn't know.
Yeah.
So there's a whole slew of things you have to learn before you start using AI. And I mean, right now, you just have to review everything very carefully because it does make mistakes and they're often fairly subtle. So
Mhm.
it's not like you could just rely on it,
Yeah.
but it
And
does
in terms
help.
of, I was going to say, just in terms of prosecution as well, one part of the prompt is you want to make sure that everything it's arguing and, what it's suggesting maybe is tracked to the actual specification of your application. You don't want it to infer kind of expert knowledge in the area of the application, which it is liable to do if you don't tell it to do so. But anyway, that's another presentation we could go through for how to prompt AI and patent prosecution for an hour. But we are quite out of time. So thank you everybody for attending today. If you have any more questions, our contact information is on the last slide. Feel free to email us or call us. We'd be happy to answer your questions. But thank you.